I'm not sure what my client means by that. I'm gonna ask him to explain it.
I mean, how can I cross-examine the state of Texas? How can I?
Yes, I believe my client, I think it just goes back to, um, being a,
Communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC.
While all this was going on, what was going through your mind at the time where you were laying on the floor?
I was gonna die. I
Now-
couldn't see anything.
I'm sorry, what was that?
I couldn't see anything.
Okay.
Oh, yeah.
All right, the court will sentence you to 30 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be restitution, if any.
In the fall of 2023, Beltran held a smoke shop store worker at gunpoint. He forced her to the ground and tied her up with zip ties. He stole more than $3,000, including vape pens and other things. So you may be asking why the lengthy prison term. The DA's office reports that Beltran has a prior criminal history, including weapons violations.
All right, Mr. Beltran,
a little closer.
have you reached an agreement with the state, or are you requesting a jury trial?
May I respond for him? We are in the midst of doing some additional discovery, Your Honor. I've already conferred with the state on this.
What additional discovery?
It's a sensitive matter.
Ms. Ferguson, on this case, we're set for 3 weeks for pre-vet Monday. All right, we're coming back on September 3rd. There will be no further resets for pre-vet bond. Does everybody understand?
Yes, Your
Yes,
Honor.
Your Honor.
All right, thank you.
Have a seat, sir.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance. Under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Mhm.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be. And it has to be allegations that it happened in Bear County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bear County, then it would come to a felony district court, state district court that's in Bear County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, Yes.
Excuse me, did the court take judicial notice of the indictment in this case?
yes,
Make its ruling, okay.
yes.
The
And
other,
then the next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction, the court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right,
Did I get that right?
Yes.
Okay.
all right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right, so if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right, so Mr. Beltran, do you understand with the charge of an aggravated robbery case? Sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? Do you have any questions about the court's ruling?
No, Your Honor.
All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without abstract subject matter jurisdiction. And the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the Seventh Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the Seventh Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no-fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331. Light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm gonna ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff. And they're the ones that are pursuing and to prosecuting me,
Mhm.
which is they're one of third party,
Okay,
and I'm not. I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
so let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bear County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything,
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr.
Yes.
Beltran, that's not to be heard right now?
All right,
Okay,
and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
yes, I am.
All right.
So the next document is entitled Court Constitutional Notice,
Mhm.
and that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So, the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir, Your Honor.
All right, the next one is state bars, virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the state bar hasn't gathered any evidence. State. do
I
you
think I
know-
just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court, does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding this collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right, does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office,
Okay.
and defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else?
Mm.
Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that worries that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right, is there anything that you don't understand about the jury trial process?
Mm.
All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, ma'am.
All right, so if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the, jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.
Ms. Martinez, how old are you currently?
53.
And do you currently live in Bear County, Texas?
Yes, I do.
How long have you lived in Bear County, Texas?
53 years.
And are you employed currently?
No,
Okay, are you married or do you have a partner?
no, my husband passed away.
Okay. Do you have children?
Yes, I do.
How many children do you have?
2.
Now I want to talk to you about something that occurred on August 4th of 2023. Do you recall that day?
Yes, I do.
How are you employed on that day?
Say it again.
Where were you working on that day?
Sugar Leaf Smoke Shop,
And where was that located?
281 South and Mogford Road.
Okay, and is that located in Bear County, Texas?
Yes,
Okay. And how long have you been working at that smoke shop prior to August of 2023?
about a year and a half.
Okay. And what shift would you work there?
Mornings.
Okay, and how long would that run about?
I would work from 10 in the morning till 4:30
Okay. And would you work alone or with a partner?
alone.
Now, on August 4th of 2023, were you working alone?
Yes, I was.
And do you recall anyone that came into the store?
Yes,
Can you tell me what you recall from that day about people going into the store?
I just had like 1 or 2 customers in the morning. And then at 2:00, is when I was robbed.
And so when the people that came in, who we're speaking about, came into the store, do you recall how many people came into the store
That morning,
regarding
the
what we're
incident,
here for today?
2.
Okay, and can you explain to the jury, what happened when the 2 people entered the store?
When the first suspect walked in, I greeted him, as I do all my customers. And a few seconds later, say 15, 20 seconds later, a second person entered my store. I greeted that person as well. And I was asked to go back to the back room to where we have games to plug them in. And as I turned to look at the games, because I had to plug them in to see that they were setting, I said, okay, as soon as they load, you can go ahead and start playing the games. And as I turned my head, the gun was in my face.
Now regarding the individual that pointed the gun at your face, do you recall any identifying marks that that person had?
Yes, under the left eye socket was a mole. And in the very back of his neck was a tattoo.
Okay. And so when this gun was pointed at you, did they tell you anything?
Told you,
Per se?
Overruled.
You may answer.
told me to get down on the ground. Put my hands behind my back. So I laid down flat, my nose and forehead on the ground with my hands behind my back. What felt like something went around my wrist, and I heard like a zip tie, like zzz, and then they kicked my legs together and did the same thing to my feet. And then I heard something break, like I could tell it was a hanger because I had clothing in the back room. And something dropped over my head, so I could, at that point I could only see the ground. But when they dropped the t-shirt, I couldn't see anything.
After the t-shirt was placed on your head, did that individual that you described with the mole and the tattoo, did he stay in the room with you, or were you able to hear where he went?
They were both still in the room. And they stepped out. I could hear tennis shoes. I could hear their shoes walk around the store. And I felt somebody come back. I heard him coming back into the back room. And I felt something like drop down on me, which were backpacks hanging on the wall. And I guess they were taking those, because I felt him step over my legs, even though I'm face down.
Okay. And in the time that this person was there, did they pay for any merchandise at all?
No.
And as an employee of the smoke shop, did you give them consent to take any of the items?
No,
Okay.
not at all.
And so, do you recall about how long you were there laying on the floor?
Anywhere from 25 to 30 minutes, because they walked in right at 2:00.
And then how are you able to get up off the floor?
Well, my hands are behind my back and I'm face down. I was able to pull my hand out of the tie wrap and it scratched my hand. And I was able to get my feet undone as well from the tie wraps.
And while all this was going on, what was going through your mind at the time where you were laying on the floor?
And I was gonna die. I
Now-
couldn't see anything.
I'm sorry, what was that?
I couldn't see anything.
Okay. And what did you feel when that gun was in your face?
My first reaction was shocked, like, is this really happening? But then in a split second, it just fear, scared, fear for my life.
Now, regarding the smoke shop, did the smoke shop have video surveillance cameras?
Inside and out.
And on that day, after you were able to free yourself, did office or deputies from the Bexar County Sheriff's Office show up to the location?
Yes.
And were you able to speak with them?
I had locked myself in the store as I called 911. And I then let in the officer.
And
Court is calling 2024 CR 4295, State versus Louis Beltran. Could I have parties announced?
Megan Galloway for the state.
Arlene Gay for Mr. Beltran.
And are you Mr. Beltran?
Yes, Your Honor.
And counsel, you've received all discovery and reviewed it with your client?
I believed I've received everything and I've reviewed discovery with my client.
Court will find that the state is in compliance with discovery. Mr. Beltran, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count one. I mean, we are proceeding on count one, waiving count two and count three.
Any objection?
No objection.
Right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count one, you're charged with aggravated robbery? That's a first-degree felony. Range of punishment is 5 to 99 years or life in prison and up to $10,000 fine. Because the state is proceeding on the habitual enhancement allegations, if those are proven to be true, then your range of punishment will be at a minimum of 25 years in the prison and up to life or a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Beltran, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And so the record can be clear. We were in the middle of a jury trial on this case, and you're freely and voluntarily deciding that you no longer wish to continue with that jury trial and you wish to enter into a plea bargain agreement.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Beltran, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count one. You're to agree that you've been previously convicted of one or two or more felonies for enhancement under 1242. Punishment is to be assessed at 30 years in the prison. There's an affirmative finding of deadly weapon, no applications, and there's to be restitution to Sugar Leaf Smoke Shop. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Yes, there has, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
To the first enhancement paragraph, how do you plead? True or not true?
True.
To the second enhancement paragraph, how do you plead? True or not true?
True.
State any evidence to support the defendant's plea.
State offers states one in attachments.
No objection.
All right, did you state you may be excused? Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. In attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and based upon your guilty plea in states exhibits one and attachments, And also, the court will find both enhancements true based upon your plea of true and based upon States Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client, would like you to follow the plea. And did you have anything you wanted to say to the judge? If you don't, that's okay, dear.
No, Your Honor.
All right, the court will sentence you to 30 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be restitution, if any, to Sugar Leaf Smoke Shop. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, so we can go off the record. Here's the thing. Was this all worth it?
No, Your
No.
Honor.
And so now you're looking at 30 years in prison for something that wasn't even worth it.
Yeah.
And the lady who testified was terrified, and she had every right to be terrified. And you're the cause of that. You're going to have to stop leaving destruction in your wake. Otherwise, you know what's going to end up happening? Either you may end up getting killed, or either you're going to be in prison for the rest of your natural life. You understand? Do better. All right, good luck to you.